there are different kinds of patents that exist, right? There's utility, there's design, there's provisional, there's something else. And so I think it'd be good if you just talked through two-sentence definition of each and an example.
Yes, there are three types of patents. There is a utility patent, which covers how it works. And that is the most powerful type of patent because it covers the function. There is going to be a design patent, which covers the how it looks. And a prime example of a design patent is the Coke bottle, where you see the ridges along the line. That's very unique. The bottle itself is not novel, right? But the ridges are novel. Now, another example of a design patent is this particular device. Guess what? Apple got a design patent on a rectangular phone with rounded edges. So that's a design patent. And that patent, Apple actually litigated against Samsung and they earned billions from it, from that simple thing. Then there's a third type, which is probably not applicable to us here. It's called a plant patent. And of course, the name plant is covering plants. So maybe it might be applicable to you if you're in the ag tech space, but we mainly deal with software and mechanical and electrical technology. So for those, you really have two types. It's the utility patent application and the design patent. And within the utility patent, you got two types. You got the provisional, which is a temporary patent. And then you got a non-provisional, which is the one that is going to actually get examined. So that's the hierarchy.
Okay, great.
Have you ever wondered how two businesses with identically the same name in different regions can coexist in trademark? In a particular scenario, those companies probably have not registered their marks federally. So if they didn't do that, you have, they call it common law trademark rights. You have trademark right as long as you're operating and selling products within a reasonable zone around your address. So let's say if I run a Pete's in Chicago and I have a Pete's in San Francisco, and they both are unregistered, they both would be able to coexist. Now, what happened when, let's say, the first Pete is in Chicago and they didn't bother to trademark it, and the second Pete in San Francisco did go through the registration process? What happened is now you got a federal right that overlays the entire United States. And that federal right is then carved out like a Swiss cheese hole in Chicago because the Chicago Pete's Pizza operated before they had applied for the trademark.
Actually, I just heard a story a couple days ago that there is a Burger King somewhere in Illinois
Wow.
that
Preceded.
existed before the chain Burger King, and they still exist as the only independent Burger King
Wow.
with the international brand.
I got to look it up. I didn't know that that existed.
I guess Burger King tried to buy them out for
Oh,
like
yeah.
years. And finally, like if you look up the court ruling, it said this is like Burger King owns
Everything else.
they own like use and ownership of the name for like everything outside of like a 20-mile radius from that one Burger King.
Yeah. 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 Now, that would poke a hole in your trademark rights, but one
Yeah.
restaurant is not going to kill you.
Yeah, and they don't use any of the same like branding or anything like that. It's not like, I don't know if you ever saw the Eddie Murphy movie Coming to America back in like the early 90s or late 80s. It was like McDonald's instead of McDonald's.
Oh,
And like they had like it was like a hood version of McDonald's, and like everything looked like kind of similar but a little bit different. And then anytime like like an agent would come by, like the owner would just like run out the back door. Okay, so let's talk about the trademark that you filed on my behalf. So we had applied for a trademark over the name Startup Hypeman, and one of my pitch formulas. The original response we got back was that it was under review, I believe because it was not specific enough. The name startup can be used in many different contexts. So can you just talk through what they said in the initial review and then how you articulated the response to secure the trademark?
so recently we worked on a trademark for Startup Hypeman. We applied for that, and ultimately there was some pushback from the trademark office. And so here's the history and how we overcame that. So we first applied for the mark as a combination, Startup Hypeman. However, the patent office was concerned that they didn't want to give the exclusivity to startup alone. They required it to be together with the Startup Hypeman together. And so the solution to that was we submitted a disclaimer to the trademark office saying that, yep, we're not claiming exclusivity to startup. It should be Startup Hypeman as a combination. And that's ultimately how we got the trademark.
Great. Let's spend a little bit of time talking about, I think if we can cover so I'll say that I think a lot of people, they see the cost of patenting or trademarking something and they're like, well, it's just some paperwork, so I'll figure it out and do it myself. Why don't you share I don't know if the word is the danger or like the concerns with if you're not a patent attorney, filling out any sort of trademark or patenting paperwork?
So as a patent attorney, I've helped a lot of founders and individual inventors obtain patent applications. I would say maybe 10 to 15% have actually done their own provisional patent application and they come to us. And so some of the issues that we see is that their applications are very thin on details. So if you have like a 1 or 2 page back of the envelope and you file that as your provisional patent application, and when we convert it into a non-provisional, it tends to be 30 to 50 pages in length because we have a lot of details that show how it works, right? And so one natural question they might say is, well, if you start off with a back of the envelope invention disclosure or provisional, and now all of a sudden you see in the non-provisional 20 or 30 pages of details, did you have possession of that? So I think the biggest problem that I've seen is lack of detail, number one. Number two, inventors do not understand the process, the journey of going through the patent office and what examiners look for. And so they would tend to think of themselves, oh, yeah, I think this invention is very simple, and let me just explain this, maybe 3 or 4 blocks. The problem with that approach is that, number one, you're doing yourself a disservice by not building up the greatness of your invention. When you think it's so simple that I can do that in, a page or 2, you're underselling yourself, right? When you go to an investor, you want to say, hey, this business is fantastic. It has huge value and it's really hard for anybody else to copy me. You don't want to go to an investor and say, it's so easy. I can do it in 2 pages, right? And then guess what? The examiner is going to review your application the same way. And so we as patent lawyers, we add value to that by putting your invention on a pedestal. We say, hey, look at this beautiful concept here. It is, amazing. So, even though it is simple, simplicity itself is in this year of non-obviousness. Steve Jobs, his products are simple and easy to use, but nobody would say that Steve Jobs' product is easy to clone, right? So we frame the invention in a way that it looks sophisticated and slick and novel. So that's the first thing, is the framing of the invention. If you as the inventor come in and said, oh yeah, this thing, I can describe it in a couple of pages, guess what? The examiner is going to think this thing is simple, obvious. Number one. Number two is, in the space of software, you run an extra hurdle of, they call it patentable subject matter, or it's called the ALICE test. You can Google this. You say ALICE, software rejection. What the examiner is saying there is, your invention could be implemented by a human mind. And even though it might take a human mind 1,000 years to do what the computer did, it's doable in a human mind. And because of that, it is an abstract matter that is not patentable. So that's basically what the ALICE is saying. Now, how do you walk around that? You walk around that by showing that your invention improves performance in some way. So let's say it could be, you can make your computer run a lot faster with your technology, or you can increase the output, the quality of the output. So let's say you invented something in the compression space. You need to show the examiner that, hey, my invention compressed the data down to 30% more efficient than the best prior art. That tells the examiner that you have done something that is more than just the concept of compressing data. So there are a lot of things that the examiner checks for at the patent office that because we deal with them all the time, we will document that in the application so that it will address the questions that the examiner has directly in the application. And that cuts down the argument. You can imagine the examiner is going to come in. Yeah, think of it this way. He's going to apply the usual test. Oh, software. Okay. Alice 101, not patentable subject matter, number one. Number two, this thing is obvious. I'm going to look at the keywords of what you do, and I'm going to hunt down those keywords from 2 or 3 patents. That's their basic algorithm. Okay. And so what you need to do is anticipate all of that. And for some inventor who is focused on coding and never seen the space to go in there and write a patent application and anticipate what's going on in the patent office, that's going to be very challenging. And think of it this way. Is your value better at writing coding the next, Google, or is it better to learn and read a book, spend a year reading the book on how to do a patent yourself and ignoring the value of what you really do as a coder? So in short, that's why lawyers are still surviving in this world, even with the AI technology and onslaught of, technological advances that possibly could say, oh, they could replace lawyers. The third thing we haven't mentioned is the strategic aspects of claiming your invention. So the first thing we've talked about is getting past the patent office. The third thing we talked about is, okay, could you think about how to claim this in a way that covers more than your specific use case? And that has significant value in the patent. So let me give you an example. I architected the Invisalign patent portfolio, and it has numerous technologies in there. 3D printing, it had computer-aided design as applied to dental, the teeth, the modeling. It had, they call it intraoral scanning technology, which is the technology that scans and digitizes your teeth structure, right? All of those things were patented. But guess what? The most powerful patent in the whole group was a patent that we said, hey, you can't have more than 3 retainers that are with a sequence indication on it. Now, Rajiv, do you know why that is significant? Why is it that there's a patent that says you can't have more than 3 retainers with a sequence indication on it? So Invisalign works by creating molds of your teeth, and each sequence that you wear, it applies pressure slightly to move your teeth by, I think, 2 millimeters at a time. That's the maximum that you physically can move a teeth without harming yourself. Okay? So guess what? The entire invention of an Invisalign is you have invisible devices you would wear. And how are you going to treat somebody if you cannot have a sequence indication on those retainers? Without that sequence, all your fancy 3D scanning and CAD technology and 3D printing technology, all that is worthless. So you can see how a value of a lawyer perching above what you've done can add a huge value add.
Nice. That was good. I would love for you to talk just about the Alice test. I've never heard of that before. And I think if you can explain it, but then also give 1 or 2 examples of abstract versus concrete that would pass the Alice test.
Have you ever heard of the Alice test as applied to software and AI and even biotechnology space? Well, there's a requirement called 35 U.S.C. Section 101 that defines patentable subject matter. And that rule excludes math, laws of nature, things that existed in nature, like let's say vitamin C, plants that already previously exist. So in the 70s, the court says that anything under the sun is patentable. And that really encouraged a lot of software patent applications to be applied for. Now, I think the problem with that is that now we have too many software patent applications and it can block the field. So the judicial trend recently is to restrict the scope of software patenting. And in a famous case called Alice, the court there enunciated a 2-part test. The first test is this potentially classifiable as an abstract matter? So could it be done in the mind? Could it be so high level that it could be done in the mind? And we'll get to an example of that. And so assuming that you fall into that threshold, which software arguably is going to go into there. Then there's the second prong that says, did you do something more than conventional to take it out of the abstract matter test? And so when they say that, they mean that did you do something that is different, that improves the efficiency of the machine or the resulting product that is, in a way, is a type of what is called obviousness test, right? So let's apply that to a tangible example. Let's say you came up with a watch or a wearable device that has the LED and it bounces lights into your skin, your veins, and the light reflects backward. And you detect that, and then you can then measure heart rate or blood pressure or glucose level. Well, I ran across into that in one case where we did that, and the examiner says, well, all you're doing is you're just sending light into the skin, measuring the reflection coming back. We even had language that was saying we have sensors to detect that the wearable device, moves relative to the skin. And when it moves, it compensates because of skin movement, right? So it's a motion compensation. And even with all that, the examiner came back and says, well, all you're doing is, shining light into the skin, and then you compensate for, using motion, sensors. That's an abstract idea. And so when we pushed back, and we said, well, how is that abstract? We have a physical device that shines light into the skin, and then another device that detects the reflection of light coming back, and then we're compensating for the motion. And then we use the output to then estimate, a particular blood pressure or a heart rate. That's very specific, right? And yet we run across that Alice 101 rejection. So we talked to the examiner, and he said, well, I noticed that you have some real-time determination in there. And real-time, you can probably throw in there and it might take it out of 101. So we did that. We did what he suggested. Guess what? The next thing comes back, he ignored his own suggestion. So sometimes with certain examiners, you can get into those traps. And so, you just have to keep on negotiating with the guy and sensing it. So unfortunately, the Alice test has the analogy into Alice in Wonderland. There is no clear boundary. And in fact, right now, there is a discussion of Congress action to basically get rid of that test, because that was a judicially created test and it just creates so much uncertainty. Depending on the examiner you get, you may just go straight by without any problem. And then some other examiner, they can stretch that definition so far out that even a mechanical device with sensors deflecting light into it, the examiner would say, this is an abstract matter of just shining light and detecting reflections. It could be done by a person. So that's an example of this controversy that's raging right now with patent attorneys, is because if you get into that trap, you got to fight hard to get out of it. But it is possible to get out.